Good evening, friends. Welcome to the 30th program of Hammurabi Tablet in the new venue and the new segment also. As on last occasion, Rahul sir informed you all that from this month onward we are going to start our new segment, which is a how-to concept. As right from our second lecture to last December 2018's program, we have covered various topics regarding under the segment of scope of practice in various areas such as medical law, sports law, insurance sector, and etc. So from this month onward, we are going to start our lecture series on how to concept. So our today's lecture is about how to initiate a cause of action in the court, and our lecturer is Advocate M N Kenia. Mr. M N Kenia is a very senior advocate from Small Causes Court, and today he is going to cover topics. I will tell you how to draft notice, how to draft plaint in various kinds of suit, how to file or lodge a complaint, how to serve writ of summons, on whom writ of summons to be served, and after service what steps should be taken. So without wasting time, I will welcome our guest. Now I request Rahul sir to welcome our guest.
So we have started with this thing. So just a minute, we'll click a photo.
Well, friends, initiation of cause of action in a court of law. Before we start, my friend Rajesh Devgarkar has a problem. He wants a solution for that. Do you agree that we should give him a solution? Yes or no?
Yes.
His problem is, he tells me that during the course of the next week, he is likely to be engaged. And he tells me that the marriage thereafter will take place in immediate future. It is his desire, it is his wish that we all should attend his marriage. His problem is that what he should do today. Any answer? He is likely to be engaged the next week. In immediate future, he is going to be married. Today, his wish, his desire is that we all should attend his marriage. What he should do today?
Invitation card.
Invitation. Any other?
Wedding booking.
Any others?
Start planning for the marriage.
Any other suggestion except the invitation? No? Now let us wait to give an answer to Rajesh. Is that clear? Now invitation Rajesh can't give today because marriage is the later thing, but engagement is not certain. I use the word he is likely to be engaged. He can't give an invitation because the place is not fixed. Date is not fixed, time is not fixed, correct? So he can't give an invitation. Today, the only course open to Rajesh is that he should give us an intimation. An intimation, information that he is going to be engaged, he is going to marry, when the marriage fixed, he can give us an invitation. Is that clear? Now, what intimation Rajesh can give is a lawyer give to the other side, which you call notice, a demand notice. A demand notice is an intimation to the other side what is going to happen. Any doubt on this? Because I want to avoid that question answer session. So if you have any question now, you can ask me. Now, what is notice of demand? What should you do? Let us take an hypothetical problem. Mr. A walks into the office of an advocate. He says that in the name of his wife, Mrs. A, he has advanced a sum of rupees 1 lakh to Mr. B, and Mr. B has executed a promissory note in favor of Mrs. A. Now, B is neither paying the principal nor paying the interest, and therefore, he tells an advocate this is his problem. Now, what advocate should do? The advocate, moment Mr. A walks into the office, the advocate is expected to go through the document, whether it is proper or not, whether the proper stamp is affixed on the document or not, whether the names written on the documents are correct or not. Everything is found in order. Then advocate gives notice to the other side. He dictates what he should say. I am instructed by Mr. A to give you this notice. I have seen in my life quite few advocates have committed that mistake by giving a notice on behalf of Mr. A, because Mr. A known to him. Therefore, he forgot that the document was in the name of Mrs. A and not Mr. A, correct? Now, I have to give notice on these facts, that notice can be over in 5 sentences. Do you agree? Notice can be over in 5 sentences. Now take it. I am concerned for my client Mrs. A, and on her behalf I have to address you as under. 1 sentence, paragraph 1 over, next paragraph, 1 sentence. The entire cause of action can be covered in that 1 sentence. My client says, for a valuable consideration paid by my client by her check, bearing number so and so, dated so and so, drawn on so and so branch, you executed a promissory note dated so and so in favor of my client, thereby agreeing or promising to repay the said amount with interest at the rate of 12% per annum on demand being made by my client in that behalf. Full stop. My client says that notwithstanding his repeated demands, you have failed and neglected to pay the principal and the interest. Paragraph over. Now next sentence. I am therefore instructed by my client to give you notice, which I hereby do, and call upon you to pay to my client or to me as his advocate the said amount of rupees 1 lakh with due interest thereon at the rate of 12% per annum within 24 hours from the date of the receipt hereof by you failing which I have peremptory instructions to adopt appropriate proceedings to recover the said amount along with interest as aforesaid, and you will have to thank yourselves for the costs and consequences arising therefrom. Fourth sentence. Is this notice over? Now you are juniors or third year law student. Mr. A may feel, because this 4-sentence notice will be over in 1 page. He may not pay you more than 50 or 100 rupees because the notice is short. He may not be satisfied with that notice. What he will say, "Arey saab, badhiya kadak notice do." He will feel that this notice very short is not kadak, majboot, nahi hai. Then what you should do? You should take that very notice in 2 or 3 pages. I think you are getting me, correct? Therefore, I have completed the entire cause of action, 1 sentence, 1 paragraph. You can split. I am concerned for my client Mrs. A. My client Mrs. A has instructed me to address you as under. My client says that she has advanced a sum of rupees 1 lakh. My client says that the said sum was advanced by her check bearing number so and so, dated so and so, drawn on such and such bank and branch. My client says that you have promised to repay the said amount on demand made by my client, etc., etc. You can split up, and that notice will run into 2 pages, 3 pages, and the client will pay you handsome fees. Okay? Now suppose you have given that notice, the other side is not responding, that Mr. A will come to you as a lawyer after 15 days, and what will you do? File the case. So you will file the case. By filing the case, you have to draft a plaint. Okay? Now before the drafting the plaint, you must be sure that you have to file a suit in which court. You must know that each court has limited pecuniary jurisdiction. If it is less than 1 crore city court, more than 1 crore in the high court, less than 1 lakh in the small causes court. Okay? You must also know that what kind of suit you will have to file. In this case is a summary suit. Sometimes you have to file short cause suit, long cause suit, RAD declaratory suit, RAE under the Rent Act, RAE and R, LE, LE and C. That is a separate topic. I request to arrange another lecture only for what sort or which circumstances which suit can be filed. But today we are concerned. Now we have come to the conclusion that a lawyer is advising Mr. A that your wife has to file a suit. Now if you have to file a suit, the first step is the plaint. Now what is plaint? You take out any dictionary and see the plaint is a mournful song, a bunch of sorrow, a complaint, statement of grievance, exhibiting your action, your pain in writing. That is the definition of the plaint. It is sorrowful song. You are exhibiting your pain, your action in writing. but you have to go through that. Mrs. A has to go through that. Mrs. A can't do it, and therefore he has engaged you as a lawyer. So you have drafted the plaint. Now by drafting the plaint, what you should keep in mind? In the other way, what are the particulars the plaint should contain? Now let us see in short the name of the court in which you are going to file a suit. In the High Court of Judicature at Bombay, in the City Civil Court at Mumbai, in the Court of Small Causes at Mumbai. Now what sort of suit you have to file? Whether it is summary suit, whether it is LC, whether it is SC, RAD, LE, etc. Now you have to write name, description, age, etc., place of residence or business of the plaintiff and the defendant. If any of the parties is minor, he is of unsound mind, then you have to make an averment to that effect. Appoint a best of kin or next friend or guardian. You have to narrate the facts which according to you constitute the cause of action. Now I have stated in the notice paragraph second, for valuable consideration paid by my client by her check, etc., you executed promissory note. That is your cause of action. That you have to narrate your cause of action in the plaint. You have to narrate the facts that the court in which you file a suit has jurisdiction. The check was given in Mumbai. Plaintiff and the defendants reside in Mumbai. Entire cause of action has arisen in Mumbai, and therefore the court has jurisdiction to try your suit. Now you have to set out reliefs. We call it prayers. What you want from the court. In our case, you can say that the defendant be ordered to pay to the plaintiff a sum of rupees so and so, along with interest on 1 lakh at the rate of so and so, from the date of the suit till payment, and other reliefs. Now, in our case, say 1 crore is the principal amount, and if you add the interest, it will be more than 1 crore. If you file a suit in the High Court, perhaps you are not interested in practicing in the High Court. Perhaps you think that if you have to engage a counsel, it may cost much, and therefore you tell your client that you have to give up part of your claim. The total dues are coming to say 1 crore and 2 lakhs. Unless you give up that 2 lakhs, you can't file a suit in the city court. If in that scenario, you have to make an averment in the plaint that this amount is due and payable by the defendant. Plaintiff hereby gives up the amount, claim amount of rupees so and so, and restrict her claim to rupees 1 crore so as to give jurisdiction to the city civil court. That statement you will have to make in the plaint. Now you have to make an averment that what amount you have to value for jurisdiction of the court on which you have to pay the court fees. You have to make an averment that your cause of action is not barred by law of limitation. You have to make another short affidavit affirming what statements you have made in the plaint we call it supporting affidavit, list of documents on which the plaintiff will rely, wakalatnama, memo of registered address, exhibit the copies of the main documents to be exhibited, list of documents on which you want to rely, court fees, docket and index, paging. Any question? No? Therefore, your plaint is now complete. If you do that, the next step, you have to take your client either to an affirming officer of a court or before a notary public, where the client will declare the plaint. So you have got an engrossed plaint duly declared by your client in your hand. Now what you should do? You go to the concerned department of that particular court and give to that clerk or the officer your engrossed plaint duly declared. Court fees are properly paid along with a white copy. That clerk will make an entry in the register which he or she is keeping. He will give you the lodging number. And you go. Now what the office of the court will do? Your plaint will be sent to an higher officer. Let us call it a checking officer. He will go through the plaint. If everything is correct, it is okay. If it is not correct, he will raise an objection. I have seen that objections sometimes are silly objections. I have seen that the objections are taken by the officer concerned for the sake of objection. But you will have to deal with it. Don't be angry that how can you do that. Be polite. Now what is silly objection? I can tell you, your plaint is of blank day of January 2019. Mr. A has to go out of Mumbai, or Mr. A was not well, he has not attended your office, and he attended on 1st February. So in that declaration clause, it will be written first. Instead of scoring of January, you have written about January, February, and you have forgotten to score of the month of January. The officer will raise an objection. According to me, it is a silly objection. He ought to have put a script. But be polite. Let him raise an objection. After few days, you go to that department, to that officer, see whether are there any objections on your plaint. Normally, it is the practice that on the back side of the docket, they write what are the objections. Go through that objections and remove that objections. Once you remove that objections, then what happens? We'll see later. But your plaint which you have filed, not only objections, it may be rejected also. It may not be taken on record. Your plaint will be rejected as it is. And you must know what are the circumstances in which your plaint is likely to be rejected. The plaint can be rejected on the ground that it does not disclose any cause of action. There is no promissory note signed by Mr. B. There is no cause of action. So your plaint will be rejected. Your plaint will be rejected if you have undervalued. You have to recover 1 lakh and you say that I put my claim or value my claim at 50 lakhs instead of 1 crore. On that ground also your plaint will be rejected. If it is undervalued, the objections will be raised that you must value it at 1 crore and pay the additional court fees within a particular time. If you don't pay the additional court fees, your plaint will be rejected. Now take an example on 10 lakhs of claim, the court fees is 50,000. Now instead of 50,000 you have paid 45,000, the deficit in the court fees. That is an objection. So you will have to pay the additional court fees so as to make it 50,000. Now an averment in the plaint raise a doubt, raise a case that your claim is barred by law of limitation. Then also your plaint will be rejected. Now you have lodged a plaint, it has been scrutinized, objections are raised, you have removed all objections. And then what happens? Now any questions till this point? No. Now you have removed your objections. That plaint goes to the highest officer of that particular court. In the city small causes court it is registrar, in the high court it is prothonotary. And he will make an endorsement that admitted on this blank day. Once the plaint is admitted, the suit numbers will be given. Now you have to remember or note down at least 4 or 5 things. What are the 4 and 5 things? The date on which you have lodged the plaint, 1. Date on which your plaint has been admitted, 2. Suit number, returnable date, and the courtroom number. These are the 5 things you must note down. Clear? The date of lodging, the date of admission, suit number, returnable date, and the courtroom number. Yes?
What's the returnable date that you are referring to?
Returnable date means when the suit will be placed on the board of a court. You can't, sir, give notice to the other side defendant without informing him that your case will be in which court on which date. That is the returnable date. Okay? Now everything is over. Your plaint is numbered. Now what is the next step? And here comes my friend's answer, invitation. When the invitation is given, now everything is certain. The place is certain, date is certain, time is certain. Correct? What will be there in Rajesh's marriage, what will be menu, that is also written in the plaint. So everything is certain, and therefore Rajesh will give an invitation. We lawyers call that invitation a writ of summons. Now writ of summons is not a love letter, or is it? It is not an invitation in that sense. It is a notice to the defendant that he has to come, he has to attend particular court on particular date at particular time to answer the cause of action. In Rajesh's marriage, we go for enjoyment. Here the defendant will also come for his own enjoyment, for his own scene, whatever he has done. Now, writ of summons. In the small causes court, the court prepares the writ of summons, whereas in the city court or in the high court, you will have to prepare the writ of summons. And for preparing writ of summons, the earlier 5 things which you have noted down, those 5 things will be incorporated in the writ of summons. So it is a notice issued by a court, an invitation issued by a court to the defendant, but it must reach that invitation to the defendant. Rajesh in his office has written an invitation in name of Mr. M N Kenia to attend the marriage, and that invitation he has kept it in his drawer. Do you expect Kenia to attend his marriage? No. Then what Rajesh should do? Huh? He should deliver that invitation to me. Correct? So we have, the plaintiff has to serve the writ of summons on the defendant. Now that writ of summons must be served in what manner? By a bailiff, in the city civil court or in the high court through the office of the Sheriff of Bombay, by courier approved by the court, by post, if the defendant is outside Mumbai, say in Thane, then the service can be effected through the court at Thane on the defendant. And now some of the judges of the High Court are taking the view that the writ of summons can be served even by WhatsApp, and that is a valid service. Now we have come to that stage that writ of summons is ready and you have chosen the way in which it must be served on the defendant. Now it must be given to whom? Rajesh wanted to invite me. His invitation addressed to me has not kept in his drawer. He has come to my residence and he has handed over that envelope to the watchman that you give it to Mr. Kenia. Is it okay? Yes, madam. No? Then it must be given to whom? He comes to my office, a peon working with me for years, and he has left before 3-4 years back. Rajesh may not be knowing that he is no more in my service, but Rajesh knows him, that peon. That peon met him in the court or on the road, and Rajesh gives him that invitation to him, कि सबको दे देना. Is it a proper service? No, then it must be given to whom? Writ of summons. Huh? One. Then? Now let us see. It must be served by a bailiff on the defendant personally. If the defendant is not there, as my friend says, on the adult member of a family, sometimes it is a partnership firm, then on an agent who was found on the premises, or on a partner of that partnership firm. Okay? Now it has been served on the defendant or on the adult member of the family. Your work is over. As an advocate for the plaintiff, your work is over. No. Then what you should do now? First of all, you tell your client, if it is service through bailiff, you tell your client to accompany the bailiff. Then the bailiff who is serving the writ of summons on the defendant will obtain his acknowledgement, his signature, time, date, and the place where the writ of summons was served. If your client is there, okay, then the joint affidavit of the bailiff and the client, or the affidavit of the bailiff, kept ready that I so and so bailiff has served the writ of summons on so and so, such and such date, such and such place, etc., etc. But here is the defendant who refuses to accept. Then what you should do? Or the what bailiff should do? I am the defendant. I accept, but I will not sign. No acknowledgement. Or I will not accept and I will say refused. Then the bailiff will affix that writ of summons along with the copy of the plaint on the outer door of the premises. Bailiff will make an acknowledgement to that effect. It must, as an advocate for the plaintiff, your duty to check whether the bailiff has made that proper endorsement, that the service has been refused. Okay? Now, up till now, the service is refused because the defendant was present. There are some circumstances on which it may happen that when the bailiff goes, the premises are closed. The defendant might have changed his address. He might have shifted to some other place. If the summons are sent by post, it may come back with the remark left. And the question of refusal doesn't arise. Then what you should do? The premises are closed. Defendant has changed the address. Or if sent by post, it has come back with the remark left. Now, is it a proper service? The court will take that, yes, you have served the defendant. Then what you should do? You must make an application to the court for substituted service. Now, what is that substituted service? You can take an order from the court that the summons be pasted on the outer door of the premises of the last known address. You do not know the new address. Therefore, the last known address on the outer door of the premises. A copy of the summons may be affixed on the notice board of the concerned court or by an advertisement in the newspapers.
So in case defendant has expired date,
Hmm?
defendant has expired date,
I am not getting.
defendant has expired,
What is it?
dependent is expired.
Defendant expired, then you have to bring his heirs on record. His heirs will be liable to the extent of the property they inherit of the defendant. But you will have to bring his heirs on record and you have to serve the writ of summons on the heirs. Now, take a case that the defendant is not in India. He has gone out of India. Then what you should do? If he has gone out of India, the summons can be served by post. By courier approved by that particular court. By fax message. By electronic mail service. If the defendant is in Pakistan or in Bangladesh, then service through the court of that particular country in which jurisdiction the defendant resides. By officer of foreign country with whom the government of India has a treaty, an agreement. In that case, your summons will be dispatched or sent through the Ministry of External Affairs. You will have to request the court to send to the Ministry of External Affairs. The government of India will have a treaty with that particular government, and then your summons will be sent to that government for service. Now let us take a case that the defendant is in jail, prison. Then what happens? Can you or can you not serve the writ of summons? He is in prison. He has been sentenced for life imprisonment. Then what will you do? If he is in prisons, summons be sent and served through officer in charge of that particular prison. Now take a case where the defendant is in armed forces, navy, then what happens? You never know where he is. He may be on border Bangladesh, China, Pakistan, or in foreign country, or at headquarters, or in India, where is his posting? You may not be knowing. Then what you should do? That summons can be served through the commanding officer in which command the defendant is. Now any questions up to this? Now you are ready. As an advocate for the plaintiff, everything is complete. Rajesh must be happy that everything is over and he can blindly write invitation to in our individual name or in our group's name. And he can as well come and say that, all right, on such and such date, I invite you to attend my marriage. So we will all go, correct? Now here we have completed the first part. Now the defendant has received the summons. Now what he should do? Who? The defendant. He has received the summons, he has got the summons. Now it is his funeral, that what he should do. And I request my friend to arrange another lecture, that what the defendant should do. Now you have completed the plaintiff's part. Mr. A, Mrs. A and the plaintiff's advocate, you have pocketed the fees, etc., etc. Be happy. Wait for the returnable date. Your affidavit of service is ready. Now it is the funeral of the defendant, that what he should do after receiving the summons. He will arrange another lecture to tell you that what defendant should do. Clear? Any questions now? नहीं है? What? See, time you have to serve before the returnable date, and in the writ of summons depends upon the nature of the suit. Before the returnable date, 10 days, 15 days, 1 month in advance, you have to serve. After the service, yes, the defendant has to file written statement, etc., etc., etc. It depends upon the nature of the suit. And therefore, he will arrange another lecture.
Certainly.
That after receiving the summons, what the defendant should do. Now, any questions? No?
No, one more.
What if we serve the plaint and it is fixed on the outer wall of the premises, and after some days we get to know that he is residing somewhere else and we get his address. So can we send it again?
If you want to, yes. If you want to, yes, there is no bar. You can write a letter also that such and such suit is filed, writ of summons is served. By abundant caution, I am sending here with a copy of the plaint and copy of the writ of summons. Please attend. The court will accept that also.
So what if the defendant doesn't get the summons then? What happens on the date of the returnable date?
What is the question?
I think she is saying if we are not able to serve before the returnable date, then what?
You get
If the defendant doesn't get the notice or the summons?
So if the defendant get the summons, then what will happen or what he will do, the another lecture is arranged and you will come to know on that date. I have used the word funeral. It is the funeral of the defendant. Today we are for the plaintiff. Your job is over.
Actually,
if the defendant doesn't get the summon, it was her question. If the defendant doesn't get,
Or suppose on or before the returnable date, for reason A, B, C, D, you are not in a position to serve. You get the returnable date, the time extended by writing a letter to the registrar. We call it a precipice. By mentioning a matter to the judge that for such and such reason the summons is not served, please extend the returnable date. That will be extended. You will have to amend your summons. Instead of the earlier returnable date, you have to write next returnable date. This is all under the Civil Procedure Code.
Sir, how will we come to know who is the commanding officer?
That you can inquire from the court, one, or the court registrar will inquire with the, say, army office. Now for Mumbai, the army office is on the opposite side of the Reserve Bank. They will tell you. Even if you ask the Sheriff of Bombay office, they will tell you. If that is not, then you can say that Mr. So-and-so is in the army and here is the writ of summons. Please find out who is the commanding officer. The army will find out.
So, if the plaintiff is minor, you want to serve the summons.
Then you serve on the, I've started by saying if the plaintiff is minor, you have made an averment and you have appointed next best friend, guardian, and serve on the guardian.
Any more questions?
No, I was told that I have to complete by 6:30. I have completed by 6:35, correct?
Because we started
Now,
at 5:35.
since you may be knowing me by name, because it has been announced that I am so and so, I may be knowing Rajesh and Siddharth. The rest of them I may not be knowing. I don't know when we are going to meet again. But as it is said that जब तक बहारों में चमन रहेंगे फूल तो खिलते ही रहेंगे, अगर रही जिंदगी तो फिर मिलते ही रहेंगे. ठीक है? Thank you very much.
Thank you for such an informative lecture, sir. Now I request Advocate Rahul sir to felicitate our guest with a memento.
This is for you, sir.
Good evening, friends. My name is Siddhi. Firstly, I would like to thank our guest, Advocate M N Kenia, for delivering such an intellectual lecture and sharing his knowledge from the stage of drafting the plaint to the stage of what the steps should be taken to serve the summons. Secondly, I would like to thank our cameraman Uday. I would like to thank Vidyut Shah from MNJ Services for his continuing support. I would like to thank IMF, IMC, Indian Merchant Chambers, and last but not least, I would like to thank all of you, the audience who came here and made this event a grand success. Thank you.
At the time our guest is writing, I will announce our next lecture. That is on February 3rd Saturday, and it is how to do research of case laws. See, we require case laws continuously in our profession, but we should know there is a path as to how we should dig out. Otherwise, we will get lost because there are a huge number of, you have seen AIRs, SCC and what not. So, how to do that? So, that will be done by a senior advocate, Satish Shah. So, he will be there and he will guide us on this particular aspect as to how to do research of case laws. Now, further, there are some new faces, so I will tell them our other programs also. For as far as the advocates are concerned, we have already started, its anniversary also over, I Enhance Advocate, where we say that an advocate who is less than 5 years has to come to that platform and he has to deliver his lecture over there. And that program is held as Malad. For that, of course, now today you have given the data, you will get the WhatsApp for that. And in case of any necessity, you can call the number, and it is arranged by Advocate Kanchan Dubey. So any advocate who wants to deliver can meet her. Another, we have a program called I Enhance Student. Now that is fundamentally for students of law colleges. That is also held at Kandivli, where we call students to come and deliver their lecture. Now that program is particularly being done by in charge is Chirag Unatkat. So you can contact him, so he can arrange the things. So I would say please participate more, because your participation is actually giving us more energy. So thank you once again. Thanks for being a part of Hammurabi. And I think I generally don't like it, but then I have to say, please subscribe for YouTube and do that bell click. Because it sounds too marketing.
I request all of you to raise for national anthem.
National anthem. Adinayak Jaya He Bharat Bhagya Vidhata Punjab Sindh Gujarat Maratha Dravida Utkal Banga Vindhya Himachal Yamuna Ganga Utkal Jaladi Taranga Tava Shubha Name Jage Tava Shubha Ashish Mage Gaye Tava Jaya Gatha Janagana Mangaladayak Jaya He Bharat Bhagya Vidhata Jaya He Jaya He Jaya He Jaya 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 He. Thank you everybody.